This is case number 20-000191, Republican National Committee and Michigan Republican Party versus the Secretary of State and Attorney General. You would invite the parties to appear and state their appearances for the record.
Good morning, Your Honor. Curtis Wilder on behalf of the plaintiffs.
Steve Etherly on behalf of the plaintiffs.
Sorry, I had some technical difficulties. Heather Meingast, Your Honor, on behalf of the state defendants.
We have a court reporter present, and Ms. Roberts will, at any point in time that she cannot hear you or understand what is being said, you're going to hear a voice that sounds like it's ethereal, but it'll be she trying to make sure that we have a complete record. With that, on behalf of the petitioners, the plaintiffs, if you would make whatever argument you deem to be necessary to augment your 116 pages of briefing, your additional evidence that you presented yesterday on October the 16th, and any other items that you think require being brought to the attention of the court.
Thank you, Your Honor. I will be brief. I would like to reserve 2 minutes for rebuttal if the court will permit.
Mr. Wilder, I'm just getting, you all just getting on, so I got to get the attorneys together first, because I've been here first and I have to find out who's who. Just a minute.
Thank you.
Mr. Wilder, who do you represent?
The Republican National Committee and the Michigan Republican Party.
Shall I have the parties restate their appearances? Ms. Roberts?
No, I wrote them down. I'm just trying to find out who they represent. It's, that's why I try to get to a hearing early so I can find out who's who and who they represent. Ms. Meingast, who do you represent?
I represent the Attorney General, Dana Nessel, and Secretary of State, Jocelyn Benson.
Mr. Erkley?
He's co-counsel with Mr. Wilder.
Yes, plaintiffs, RNC, and Michigan Republican Party.
Are we clear to begin?
Yes.
On behalf of the plaintiff, please.
Thank you, Your Honor. I simply wanted to emphasize several points on the actual controversy question. First, the nature of plaintiff's mission is electing Republican candidates and promoting Republican values. And they do that within a competitive electoral structure that's defined by the election laws like the two at issue here today. Plaintiffs argued in Michigan Alliance that their interests weren't adequately represented by the state. Your Honor disagreed with that. But the state's decision now not to defend those laws on appeal, as is its right, creates a controversy and adversity between the parties here. And we cited to Miller and quoted Miller in the Sixth Circuit saying that a decision not to appeal by an original party can constitute inadequate representation of another party's interests.
Counsel, would you believe that since the court has allowed both the Michigan House of Representatives and the Michigan Senate to intervene in the Michigan Alliance case, you believe that you would more adequately represent the interests of those who believe, frankly, that I was wrong than they would?
So, Your Honor, as I understand it, the Michigan legislature is defending the law. What the Michigan Republican Party and the Republican National Committee would defend would be their interest in electing Republican candidates. Now, the fact that both houses of the legislature may be Republican doesn't mean that that's the interest that they would be defending. And furthermore, Michigan Alliance takes the position that the legislature doesn't have standing in the Court of Appeals. And if the Court of Appeals agree with that, we're back in the same situation that Justice Viviano referenced, a friendly scrimmage where there's nobody to defend the law or any interests of the Republican Party. So we believe that we have a clear actual controversy to defend our discrete interests that no other party can particularly defend. And we assert that the Republican parties and their candidates are injured because the injunction creates a broader range of competitive tactics than existing law permits. Believing that the statutes are facially constitutional, which several courts have held, the plaintiffs have had a reliance interest on those laws, and they've built their competitive electoral environment around those laws. And unlike in the past, where Republican candidates and the plaintiffs would be competing against Democrat candidates and the Democratic Party, now there's a new element here, third-party organizations that can handle ballots, which was previously illegal. So we think that that does heighten the injury and the interest in the Republican Party in defending their interests. We provided evidence of that through the affidavit of Ryan Terrell. We've also argued in our brief that the statutes are also constitutional as applied, in addition to the findings that have been made that they're facially constitutional. And I won't cite through that, but we've, with regard to the ballot harvesting ban, we've cited to Crawford and Purcell, the Carter-Baker Commission report, and the federal district court's ruling and priorities. And with regard to the ballot receipt deadline, we've relied on League of Women Voters, although expressly stating that it was a facial challenge they were analyzing. We believe there's language within the opinion that goes toward an as applied challenge. Specifically, the court held there must be a deadline, that the deadline does not effectively preclude a voter from completing the process. That sounds like as applied of voting by absentee ballot during the 40 days before the election. And further, that they must, if they're going to vote by absentee in mail, they should do so sufficiently in advance of the election to ensure the ballot is delivered by the deadline. And even though the deadline has moved here, they still have certain obligations to deliver that ballot by the deadline. We also did provide a supplemental filing this morning by Thomas J. Marshall, who's the General Counsel and Executive Vice President of the United States Postal Service. And really that is mostly responsive to Exhibit 10 of Michigan Alliance's Exhibit Part 2, Appendix Part 2, that was filed October 9, the expert report of Dr. Kenneth Meyer on the times that apply to the Postal Service, which also has about 8 rulings directing them to impose certain time limits or in time delivery mandates. So unless the court has any other questions, I will rest the remainder of my argument on the briefs.
Thank you.
Thank you.
On behalf of the Attorney General and the Secretary of State.
Good morning, Your Honor. Heather Mine-Guest again on behalf of the state. Well, I know the court's read our very short response. And so, you know, from our perspective, the case doesn't seem to be properly before the court because there doesn't really seem to be a justiciable controversy between the plaintiffs and the 2 state defendants here. And this really is because our position here is sort of is a compelled position. I mean, we're bound by the summary disposition and permanent injunction orders that were issued over in the My Alliance case. And from my perspective, I'm not sure how you can create a controversy between parties when one position's party is compelled by an order in a separate case. So, I mean, that's really pretty much, you know, the gist of it. I just don't see that this case is properly laid before the court because I don't see that there's an actual sort of justiciable controversy here created between the plaintiffs and these 2 defendants in the particular circumstances. I mean, if a compelled force position in this case is enough for a controversy, then I guess so be it. I mean, if I had filed a substantive brief here, it wouldn't have been anything other than stating, you're right, we're bound by the injunction and we're not enforcing the statutes. So, from my perspective, our position that it isn't properly laid before the court. I don't really have much to add beyond that. Our legal position hasn't changed between the two cases. The fact that we're not appealing over in the My Alliance case doesn't change our legal position. We defended before your honor in the Michigan Alliance case, and we lost and we didn't appeal. And now we're bound by those judgments. But our legal position hasn't changed. We simply did not appeal. So I have nothing else to offer in this case other than, yes, we are presently bound by the permanent injunction and summary disposition that was entered in that case.
Anything finally, Mr. Wilder?
Only that, Your Honor, the state was not required not to appeal. So the fact that they did not appeal again has created the controversy.
Thank you. You will get a ruling by Monday at noon.
Thank you, Your Honor.
Matter is adjourned. Thank you.
Thank you.